Our webinar today is being held on the lands of the Wathaurong people, and I wish to acknowledge them as the traditional owners. I would also like to pay my respects to their elders past, present, and Aboriginal elders of other communities who may be joining us today. Always was, always will be.
Well, hello everybody. Thank you for joining us tonight for the Discipline and Terminations webinar that we're running here in July. I hope everyone has got a glass of wine and they've kicked their shoes off, and you know, it's been a hectic couple of weeks, certainly at Strawberry Seed. So I'm sure, I know talking to a number of our clients that it's also like that everywhere at the moment. So hopefully you can sit back and just learn a little bit tonight. And there will be a recording sent out to you later, and also one put on our website and YouTube. So if you have to go halfway through, don't worry about it, you will get a full recording. So let's begin. For those that are not familiar with us, my name is Carli Saw. I'm the Director of Strawberry Seed Consulting, and we are a team of HR experts that help small businesses all around Australia. So in regards to where we fit in, we are just another advisor to your business. So your accountant sets up your financial systems and gives you financial advice, and we give you people systems and people advice. So we're just another piece of the puzzle in regards to surrounding yourself by people who are experts in their field, so that allows you to be an expert in your field. So before we talk about termination, we need to just briefly touch on managing employees, because let's be honest, if the hope is that if you set up employees for success, then we won't be talking about, or you won't require any of the things I'm going to talk about today around discipline as well as termination. So there's sort of three main pillars that we talk about at Strawberry Seed in regards to management of employees. And those are accountability, boundaries, and expectations. And all of these three things, if done well, can lead to clarity for not just the employee, but also the entire team and the management as well. So clear expectations are set for the employee when they start, and also along the way of what's expected of them in their role. What's the level of performance that is expected of them? And around that, you need to set some boundaries. For example, you might say, well, we work flexibly, but what does it actually mean? You work flexibly, but to what point? You know, where are I guess the fence that needs to be put up around those expectations? It may be that you can work flexibly, but you are expected to be available for clients between a particular time of day. And so by setting clear expectations and clear boundaries, it actually makes it a lot easier to hold employees accountable, because you know, you've had those conversations, you know that you've set some clarity for them, and then if they're working outside of those expectations or outside of those boundaries, you can hold them accountable and have some conversations with them. And really, these are the things that we like to see happening, and we like to know are going on. And often the first questions we ask when someone comes to us with an issue are, have you set some clear expectations, boundaries, and have you been holding people accountable to those? But what happens when you've done all that and for some reason somebody is not performing, or they're displaying behaviours that are not acceptable in the workplace? And I guess that's what we're here to talk about today. And the reason I called it "Why Does No One Talk About It Until It's Too Late" is a lot of people avoid understanding about discipline and termination, hoping they'll never have to deal with it. But I can assure you, understanding the requirements around it when you don't need it, in case you do one day, is much better, because you're more likely to follow a process where you will not find yourself putting your business at risk. So let me start off by talking about the magic number. The first question we ask clients when they come to us, when they require a disciplinary process for their employees, is how many employees do you have? Now, the magic number is 15, because at 15 or more, you move outside of the small business fair dismissal code into the realm of being just any other business, and from 15 to 1,500 to 15,000, they're the same requirements. So they're also, as you'll see in a moment as we go through them, different requirements for employers that have less than 15 employees. So that really is a magic number for us to understand, and it's often the first one that we ask. And you should understand, based on the size of your business, what the expectations are based on the size, and also when you're going to tip over that number, what the expectations will change to be. So the next question we generally ask after how many employees do you have is how long have they worked for you? And there's two reasons for this, because we want to know, is that employee still in their probationary period, or is the employee still in their minimum employment period? There's a little bit of confusion sometimes around probationary period. It's not a legal requirement, it's a contractual requirement. And it's, if you don't have a contract that has a probationary period, there is no probationary period. Often it comes into play because the probationary period is linked to notice. So you might say in the probationary period of either 3 or 6 months, the employee has a notice period just in line with the National Employment Standards of 1 week. However, once they're out of that probationary period, that might increase to say 4 weeks or 2 weeks. So it's really important to sort of think about first, are they still in their probationary period? And we are certainly seeing a really huge increase at the moment of employers terminating people in their probationary period. Why is that? Well, it's because the recruitment market at the moment is a nightmare, to put it bluntly, and it's a nightmare across every industry. And so what that's causing is employers to make decisions to hire someone and take a chance on them that they may not have if they had more time, more candidates available. And we're probably getting 2 to 3 calls a week of people who are going, this person is not right for my business and I need to move them on. So one of the questions that I noticed we had in regards to participants today was, can you extend your probationary period? And the answer is yes, you can, through mutual agreement with the employee. Now, I'm going to preface that, and I'm going to come back to that because I want to talk about minimum employment period first. Minimum employment period is the qualification period before unfair dismissal is on the table. If you're a business with that is less than that magic number of 15, then your minimum employment period is 12 months before unfair dismissal is on the table. And essentially what that means is that during that minimum employment period, it is a period of time when you've got as an employer to assess whether someone is the right fit for their business. And you are not required to go through as robust a disciplinary process. Even employees in their minimum employment period, you can simply say this person is not the right fit for us for these reasons and move them on. Now, if you have more than 15 employees, then that comes back to 6 months. So it's really important to understand where that is. And sometimes if you're an employer who has more than 15 employees and a 6-month probation, then they might be in alignment. However, if you're a smaller business and you have 12 months in the minimum employment period, you could definitely consider extending someone's probationary period. If you have more than 15 and you have a 6-month probationary period, even if you extend their probationary period, the minimum employment period will still be over. So you'll still have to go through a more robust process. So it's really important to understand that they're 2 different milestones and they have different implications. And certainly it is a lot more risk-free to terminate someone in their minimum employment period. And to be honest, from our perspective as HR practitioners, that is the question we care about. Is the employee still in their minimum employment period? Because that's going to dictate the advice that we give next. So in regards to the disciplinary process, where do you start? Well, we always start by asking, what is the issue that needs to be addressed? So is there a behavioural issue or a performance issue that needs to be addressed with the employee? Have you given them some informal feedback and the issue just hasn't been resolved? Or is the issue serious enough to jump straight into a formal disciplinary process? And we're going to certainly be talking through that a lot more today. And I'll go through everyone's questions at the end. So if anyone does have questions, please make sure that you pop them in, and I will go through all of them at the end. So how do you start? My first question, after we've established that there's an issue to be dealt with, is do you actually understand the issue? And the reason I ask this is we sometimes get employers that say that can't necessarily explain the issue to us. If you're going to sit down and explain the issue to an employee, you need to be clear on it. You need to be clear about what the issue is. So it can't be something vague like, oh, there's just something off. They're not quite a good fit for our culture. Well, explain that to me. If you can't explain to another person why they're not a good fit for the culture, then you need to go away and explore the issue further. Do you have all the information that you need to move forward with a disciplinary process? So have you gathered all the information you need? So if it's a performance issue, have you actually looked at, do you have all the numbers? Have you analysed them? Do you know what they mean? Because if you're going to sit down with an employee and explain to them what you need them to fix, you need to be clear on it yourself. And the other thing as an employee you really need to understand is what actions or outcomes are going to be required from the employee to move it forward. Again, you can't be vague going into this process. You need to be clear on these things yourself. Have I identified what the actual issue or issues are? And it is really common for someone to come to us and say, well, it's not just one issue, there's a whole shopping list of issues. Because let's be honest, sometimes we avoid those awkward conversations with employees until they compound to being a number of issues. And sometimes that's because those issues are small. They're not always big issues. I mean, it's pretty easy to deal with a big issue. Well, it may not feel easy to everyone, but it can be a lot easier to deal with a big issue than it can be to deal with a lot of little issues. And recently one of our clients used the term, it's like someone is throwing marshmallows at me. None of them are leaving a bruise, none of them hurt, but it's just getting really annoying. And I think that was a great analogy for all those tiny little things that someone might be doing, that when you add them all together, it's showing that they may not be the right fit for your organisation. But you do need to articulate what these are. And sometimes our clients do get quite worried that they sound like a lot of petty little things. But when you start to put them together, what you realise is they're examples of a larger issue. So it's important to sit down and think this process through before you take the step of meeting with an employee. So let's get into warnings. So a warning process can be informal, it can be formal, and it's a procedure aimed at resolving a problem basically in one or two ways. So ideally, the outcome we're looking for is the employee will improve their performance or change their conduct. Or if they fail to make that improvement in response to the warning and the support that you've given them, it may result in termination of employment. And the processes that you follow through that process really need to be fair and transparent to both the employee and the employer. There's myths out there that you just can't get rid of someone. Well, that's not true. But our industrial system is built on what's known as a fair and reasonable process. Has the person been given a fair and reasonable opportunity to fix a problem, to make changes, but they're also adults. So when you're managing adults, if you've set those clear expectations, boundaries, hold them accountable, this is the hold them accountable part. If someone is not meeting those and you now have to think about how you're going to address those concerns. So I want to talk about procedural fairness because this really starts to, as you're giving a warning, procedural fairness is really important. So this is essentially the process that you're expected to follow by Fair Work. And whenever they're looking at whether something's fair, just and reasonable as an unfair dismissal, they're going to ask, have you followed a reasonable process? And this is, in a nutshell, what procedural fairness looks like. So it's telling the employee what the issue is. It's giving the employee a chance to tell their side of the story. It's demonstrating that you have considered their response, that you haven't gone in with the answer already decided in your head. It's warning the employee that their performance or their conduct is not good enough and that they can lose their job if they don't make the improvements. It's not unreasonably refusing the employee to have a support person, and we will get into support people through the presentation. It's giving the employee an opportunity to respond to the action that is being considered before the decision is made. And it's following your own company procedures. And we're going to break this down a little bit more. But essentially, this is what we're trying to achieve through warnings. Warnings allow you to demonstrate that you have provided this procedural fairness to employees. And we often get asked, oh, well, how many warnings do I have to give? How, you know, do I have to go first, like a verbal warning, and then a written warning, and then a second written warning, and then a final warning? And the answer is no, not in every circumstance, but it depends what the issue is. And I'd love to be able to give you a blanket rule of thumb, but it's really specific to the situation at hand. And we'll go into that in more detail. So, back to warnings. It is important to think about the type of issue you're dealing with when you're issuing a warning. So matters relating to underperformance should be supported by clarification of expectations, support and training prior to actually issuing a formal warning or disciplinary action. If someone's not performing and you can't demonstrate that you've had given them the opportunity to sort of clarify things, check in with them, give them some feedback, give them some training and support before you've jumped into a formal warning process, that's a bit of a red flag. Misconduct can also be supported by clarification of expectations around the types of behaviours. It may include training and support, but it may also attract disciplinary sanctions because there's evidence that supports what the person has done, that they should have reasonably known what was required and that it would be a breach of that requirement. So again, we'll get into some of these in more detail. And finally, serious misconduct. And look, serious misconduct has a very high burden of proof, and it generally results in a serious outcome such as going directly to final warning or termination of the employment relationship. But one of the things I'll emphasise is that serious misconduct, just because it feels serious to you, doesn't actually make it serious misconduct. So you're thinking about going down the path of sitting down and giving someone a warning. You really want to prepare. And I've already touched on a few questions about, do you understand the issue? Do you understand the outcomes that you want? So you do have to have concern for the other person's response. You need to be clear on what the purpose of the conversation is and what do you want to get out of it. And in a warning conversation, the purpose should be to provide feedback to the employee about the behaviours or conduct that they need to change or the performance they need to improve. And your intent really should be to give them the feedback and let them know that if they don't change that behaviour, their job is at risk. But unfortunately, a lot of people go into warning meetings going, I just want to set up someone to get rid of them. The ideal outcome of a warning process, unless it's serious misconduct, should be we want the behaviour to stop, we want the performance to improve, whatever the issue is, and give the employee the opportunity to do so. So be clear on what action you need them to change, or what behaviour you need them to change, what action that you need them to take. Think about how you're going to deliver that message, what language you're going to use. You need to choose language when giving feedback that's about not directed to the person, it's addressing the behaviour. They're not a bad person, they have demonstrated behaviour that is not acceptable. And so you need to be clear on what that expectation is and what they need to change. You need to listen as well as speak. Well, you need to be prepared to go into these conversations. And look, there are times in these conversations where someone will try and take it off track. So the more prepared you are, the easier it is to keep it on track. But you do need to be willing to listen and actively listen to what they're saying. Because the reason procedural fairness requires you to give an employee the opportunity to respond is it gives them the opportunity to explain things that you might not be aware of. You want to avoid ambiguity. You don't want to use really broad terms like you always, you never. That's probably not true. You don't want to say things like, oh, you've really got an attitude problem. what does that actually mean? What does someone change about an attitude problem? You need to be specific. You need to have examples of what you're talking about. So you might say, well, you know, I've really noticed a change in your behaviour recently, and the way that you're responding to people. You've been very abrupt. You've been quite short with people. You've been quick to anger. Can you explain what's happened? Because that's really, you know, not how you used to be. But it's clear on what the behaviour is you're addressing. And take notes. I cannot emphasise enough, and we'll talk about documentation. Take a lot of notes. So it is quite common to start off with a more informal coaching or counselling session. You know, you sit down, you're having an informal conversation with someone about their conduct and what you want them to change. And all process, you know, unless it's something that's quite serious, all processes really probably should start with an informal, you know, conversation. And I mean, one of the questions we had is, when do you move from an informal process to a formal process? And from my perspective, unless it's serious misconduct, unless it's something quite serious and you jump straight into a formal disciplinary process, you move to a more formal process after you've tried the informal, after you've just tried sitting down and giving the employee some feedback. You've given them feedback about what they need to change, what adjustments they need to make. You've been clear on, you know, those expectations again and those boundaries. You know, I need you to, you know, you've been coming in late. I need you to turn up on time. And you need to document that discussion. A lot of these discussions are quite informal and you don't want to make them formal, and that's okay. But documenting doesn't have to be a formal letter. In these instances, what I really encourage you to do is to follow up a conversation. So if you have a conversation with an employee during the day and you sit down and you say, look, you know, I really need you to you know, next time I need you to demonstrate this behaviour, or next time you have a customer that comes in and you have that circumstance, what I really need you to do is follow this process that we have trained you on before. Let's do a bit of a revision on it. After that conversation, send them a text, send them an email, say, hey, thanks for that chat today. It was great that we could talk about that. Thanks for taking my feedback on board, just so we're both on the same page. Next time that happens, this is what I need you to do. Please let me know if you understand it any differently or you have any questions. That's documentation. It's time and date stamp, particularly if it's an email or a text. And if appropriate, depending on what the circumstances are, include a time frame that you're going to review it or look back on it or something like that. And it's up to you as a manager to then monitor that person's performance. And if the informal process doesn't resolve the issue, then you may need to move on to a more formal process. For some people, they just don't take it on board until it gets formal. After 26 years in HR, that's just the reality. 9 times out of 10, though, I think if you tell someone you need them to fix something or change their behaviour, and you actually tell them and give them that feedback, they'll make the changes required. So, you know, if you think about it, you give informal coaching and feedback to people all the time, every day at work. Hey, that was such there. Thanks for getting that report in. Next time, could you do it in a different format? Or next time, could you also copy someone else in? That's informal feedback. But it's when you've had that conversation every month, the last 3 months, when that person had to get that report in, and you're like, you know what, we've had this conversation before. You know, I really need you to make this change and take what I'm saying seriously. And if they don't, we move to a more formal process. So what does a formal disciplinary meeting look like? Well, first of all, you need to tell the employee what the meeting is about. There is this myth out there that you just want to spring it on somebody. If you are moving to a formal meeting where you're going to discuss someone's performance issues or you're going to discuss their conduct, then you need to make it clear. I need to have a meeting with you. I need to talk about a couple of issues with your performance. You should offer a support person. Now, it is not compulsory by law to offer a support person. We recently had a client who said that they had an employee ask for a support person in their performance review. I think they knew what might have been coming, but the performance review was to give them feedback. It wasn't a disciplinary process, so there's no requirement to have a support person there. However, if you're going to be giving someone a warning potentially and telling them that, you know, their job is at risk if they don't change their behaviour, offering a support person is a really important part of that process of showing that it was fair and reasonable. And as I said, I'll talk about support people a little bit more as we go along. You need to explain the exact nature of the problem, and you need to give examples. You need to, again, this is why I start with, what are the actual issues? You need to understand them because you're going to have to articulate them. And when we say to clients all the time, if you can't tell us what the issue is and be clear, then you are not ready to talk to that employee. You need to detail any history of previous related matters or warnings that have happened in the previous sort of 12-month period. You don't want to bring up an issue that happened 3 years ago. If you give someone a warning on an unrelated issue 3 years ago, now is not the time to bring that up. You know, it has to be related to this process. It may be, look, we've had several conversations over the last couple of months on this particular issue, and the same error is still occurring, or the same behaviour is still occurring. That's why we're having this conversation. You need to detail any action that be specific about the action that they're required to take. Do they need to stop doing something, start doing something, make changes? And you also need to articulate how you're going to support them. So you may say, look, we're going to go through this process with you again. We're going to get you mentored by another employee. Again, it's going to depend on what the issue actually is. You might adjust their workload for a period of time to allow them to come up to standard. But you need to be clear about what the behaviour or what the performance is that you're after. What does it look like? So that they are clear on the expectations. You need to ensure they understand. You know, you need to ask whether they understand, you know, what you're asking of them. And, you know, it's a really good idea to ask them for a solution. You know, right, walking into these meetings and saying, here's the issues we have. Can you explain to me how we got here? Or, you know, this is my concern. So why don't, you know, how do you think we got to this point? What do I need to know that I don't know? And ask them what they think the solution is. Like if it's a behavioural issue, what could you do different next time? How could we ensure this doesn't happen again? How do you think we can help improve your performance? Get the employee involved in the solution. And I can't emphasise enough that you need to ensure part of this process is giving the employee that opportunity to respond. That is part of the procedural fairness that is required under unfair dismissal. And look, not everybody's going to. I've had employees sit in meetings and just nod and or shake their head or just sit there with their arms crossed. But you need to say, you know, do you have anything that you'd like to add? You know, would you like to explain anything else to me? Give them that opportunity. And then you need to consider their response before deciding what the next step is. And I think this is a really underrated part of the process because they won't tell you something you weren't aware of. You go in all guns blazing, and I've seen it many times. The manager goes in, I'm ready to give this person a warning. But once they actually put the allegations to the employee, and the employee is like going, oh my God, I didn't realise, like someone else told me I had to do it this way, or, you know, well, this happened and this happened and this happened. And suddenly you have all this new information you didn't have before. And it may be that you go, you know what, in this instance, I've decided not to give you a warning, but let's be clear on the expectations moving forward. And as long as these changes are made, then we won't take it any further. Or you may say, look, I've heard what you've had to say, but based on what has happened, we are going to provide you with a warning. So you need to advise the employee of the consequences. And that's basically saying, if there's no improvement within the time frame you've agreed, or it is a repeat of that particular issue, if it's misconduct, then further disciplinary action may be taken, and that can be up to and including the termination of your employment. Now, in terms of the number of warnings, again, it comes back to what is the issue. If we're talking about someone being late, you might do 2 or 3, you might do 2 written warnings before a final warning, because it's not a really serious issue, but it's something that needs to be addressed. And if you've known you've given someone 2 previous written warnings and they're still turning up late, they're either incapable of turning up on time or they're choosing not to. But this is the step a lot of people miss, because you have the hard conversation about giving the feedback and all that sort of thing, but they need to walk away understanding that if they don't make changes, it could result in the termination of their employment. And that's really key. If we're talking about a final warning, if there's been previous warnings or it's a serious issue, then it may be that the final warning says, let us be clear, if you don't make these changes, this will result in your termination. And it needs to be abundantly clear that they understand the consequences. Document the discussion. And this is where, again, part of the documentation to be able to prove that you've provided procedural fairness. You don't walk into a warning meeting with a written warning already written out. You should know whether it's going to be a warning now. But then post that warning meeting, you should then document in a letter, here are the allegations, we met with you on this day, here are the allegations we put to you, here's how you responded, here is what we agreed moving forward, and here are the consequences if that doesn't change. So the actual warning letter is a summary of what happened. And that's also how you demonstrate that you didn't walk into that meeting with your mind made up. One of the questions I saw that we had was, what if an employee refuses a warning? They can't refuse a warning. So they can refuse to sign it, because you can ask, I believe you should ask someone to sign to say that they've read and understood it. And if you do that and they say, well, I refuse to do that, then you make a note on it that says, we issued this to the employee and they refused to sign it. Them refusing to sign it doesn't make it go away. It doesn't mean it didn't happen. One of the other things that was mentioned in the questions was performance improvement plans, or PIPs, as we call them. And essentially, they can be something that goes hand in hand with the warning process, particularly when there's performance issues that need to be addressed. And a performance improvement plan is essentially just a plan that outlines very clearly to the employee the different issues that they have to address, how to address them, how you're going to support them, and what the consequences will be. And it's just put in a formal plan, and it can go hand in hand with a warning. It's usually something that you put in place when there's multiple issues that need to be addressed. And what it does is it's sort of saying to the employee, here's what we need you to address. We're going to meet every 2 weeks to go through these issues. And if at the end of the 8-week period or 12-week period that you set on that plan, you aren't able to demonstrate that you have the ability to move up to the required standard, it will result in your termination. And it's just another way to demonstrate that you've gone through the process, but they're not essential. Again, I cannot emphasize enough that before making a decision on a disciplinary matter and the next steps to take, ensure that the employees had the opportunity to consider the claims against them and respond. It is such a fundamental part of the process. And I think, too many people miss that part. So it is really something you need to ask yourself before we do start to talk about termination is, have I given an employee an opportunity to consider this and respond to the allegations? I just want to touch a little bit on, I guess, where the burden of proof falls, but also, we often get asked about evidence. What evidence do I have? So in terms of the standards that are used at an unfair dismissal level in determining whether allegations of misconduct are substantiated, it runs on the balance of probabilities. So it's not like in criminal law where it has to be, a certain standard of proof. It is the balance of probabilities. So is there sufficient evidence to substantiate the allegations? And you've got to look at what's known as the Brigginshaw principle, which comes from civil law, which is basically the more serious the allegation against the individual, the higher the standard of proof should be. And that is why there's a much higher standard of proof on serious misconduct. So in civil matters, the establishment is the balance of probabilities, and it is less than what you'd see in a criminal matter, which is beyond reasonable doubt. And essentially that means with everything I've got available to me, with all the information, do I believe the behaviour occurred if you've done an investigation, if you've gone and gathered the information, and you can say, and the employer's going, no, none of it happened, and you're going, well, hang on, this is behaviour you've demonstrated in the past. I've got 3 people who saw that behaviour be demonstrated. I understand that you're saying that it didn't happen, but on the balance of probabilities, I believe it did, based on past performance and the fact that I've got 3 witnesses. So as far as I'm concerned, it happened, and I'm providing you with the warning. Now, before I jump into termination, I guess one of the analogies we often use in our business when we're talking to clients is getting on the bus. So really the process of providing warnings and providing feedback is about giving an employee the opportunity to get on board and take on board your feedback and make the changes required. You know, there's so many different issues that could come up in terms of needing disciplinary process. So it is, you know, it'd be impossible to go through them all today. But when we're talking about particularly things like cultural fit and whether an employee is willing to, you know, go along with changes in the business or make changes that are required, you're essentially basically saying to them, look, this is the direction we're heading in. We've given you the information you need to understand what changes you need to make. You've got a choice now. You either step on the bus and go in that direction with us, or you step off. I do want to emphasise that the worst thing you can say to someone in a disciplinary meeting is you need to go away and decide whether you want to work here, because that can be construed as you know, basically saying, giving the employee no choice but to resign, constructive dismissal. But what you can say is, these are our expectations. Their expectations are not going to change. We need you to consider how you know, how you're going to meet them, and what changes you need to personally make to meet those challenges, because they're not going to change. This is what our expectation is of you. So let's jump in to termination. These are the valid reasons for dismissing an employee: capacity or underperformance, conduct, either serious misconduct or just misconduct, and genuine redundancy. Redundancy is not the solution for, you know, I want to get rid of this person. Redundancy means the position, not the person, is made redundant. A position is made redundant. So either a position is no longer required to be done by anybody, or you are redistributing that person's you know, role and responsibilities can be redistributed through other roles, or you no longer have a full-time position, there's only 20 hours a week available. That would make a position redundant. But redundancy is about the position, not the person. Or, you know, you have 5 people doing that job, you have 5 receptionists and you only need 3. And after a business review, you've established the business case that 3 is the right amount, so you need to reduce from 5 down to 3. There's still a case of genuine redundancy, because you no longer need 5 positions, you only need 3. And we often get asked, can I just make this person redundant when there's a performance issue? And they can cause you a lot of risk down the track if an unfair dismissal is made, because I'll say it's not a genuine redundancy. So sometimes you get lucky and you're restructuring at the time where someone is underperforming, but and I'm not going to talk any more about redundancy today, but you know, redundancy is not a solution to getting rid of someone. So if I talk about capacity and underperformance, capacity is the employee's ability to do the job that is as required by the employer. It also includes the employee's ability to do the work they were employed to do. Do they have the ability to do the work that you employed them to do? Underperformance occurs where someone is falling below the standard that is required of their work. So it's not a conduct issue, it's a shortfall in performance. It relates to matters such as quality or quantity of outputs, productivity, meeting deadlines or targets. And the appropriate test is not whether the employee was working at their personal best, but whether the work was performed satisfactorily when looked at objectively. So you need to step back and say, well, okay, is it that the person's not doing it how I would do it, but they're actually getting the job done? Or are they not working, when I compare them to other employees in the same position, holding them to the same standard, they're not up to the standard that's required. Misconduct, on the other hand, occurs when a behavioural issue results in expectations not being met. So poor conduct of the individual rather than a skill or knowledge deficit, which is a performance issue. And look, sometimes it's both. Sometimes there is a shopping list of things that are going on and you need to sort of work out what you're going to address. So this often does relate to things like attitude issues, might be disregard for rules, failure to obey or adhere to set standards within the organisation, not attending work on time, or not following, company procedures or policies. Serious misconduct is conduct that is willful or deliberate and is inconsistent with the continuation of the employment contract. It's not determined by how serious you feel it is, and it is really something that we see a lot where someone say, this is serious misconduct. I'm like, no, it feels serious to you, and I understand why it feels serious to you, but it doesn't come under the definition of willful or deliberate behaviour that is inconsistent with the continuation of employment. So it's when an employee causes serious and imminent risk to health and safety of another person or to the reputation or profits of their employee's business, or deliberately behaves in a way that's inconsistent with continuing their employment. And we are talking a high burden of proof here because it's serious. And part of the reason is serious misconduct means you're terminating the employee immediately and they're not getting any notice. So you're taking away entitlements as such. So serious misconduct might be things like theft or fraud, assault, being drunk at work. Those kind of things are really that high burden of proof on what is serious misconduct. So you've gone through the warning process. You've given the employee warnings that are, the level of warnings that are appropriate for their behaviour. Again, you can jump straight into a final warning if someone's behaviour is serious enough. If you've decided that it's most likely time to terminate an employee, then you need to arrange a formal meeting with them and you need to explain what that meeting is about. And you also need to offer them a support person. They might choose not to bring one, but you need to offer a support person. A really good idea if we've got to the point of termination is to issue what's called a show cause letter, which is essentially outlining for the employee exactly the issues that are going to be raised at that meeting. A little bit of the history and say, we're going to meet with you at this day, at this time. You're welcome to bring a support person, and these are the issues that we're going to be addressing with you. And, if you're unable to provide us with any evidence to, substantiate these, allegations, then your employment will be terminated. Now, I've seen instances where you give that letter to an employee and they resign immediately because they know that they've done it, or they know that they're not going to be able to, they just don't want to go through the process and they'll resign. One of my favourite examples I give is of a bookkeeper who worked for one of our clients who was paying themselves 40 hours a week, even though they were only on a 38-hour week, was one of the issues. And essentially I said, well, that's quite an easy one because she's either fraudulently paying herself 2 hours a week more, or she's incompetent at her job because as a bookkeeper, she didn't realise she's paying herself for 40 weeks instead of 40 hours instead of 38 hours. But it's, again, when we issued her with a letter that had that as one of the allegations, she just resigned. She didn't want to go through the process. So you need to, again, very similar to the warnings, you need to explain the exact nature of the problem. You need to provide those examples. You need to provide a history of the previous related matters and warnings. There shouldn't be a lot of new information at a termination meeting unless it's sort of the final straw that has happened that has brought you to that point. And it should be in line with previous warnings that have happened unless it's caused serious misconduct. You need to detail what's happened since the previous warning. You need to give them the opportunity to respond. And you need to consider their response to the allegations. If that response is not satisfactory, termination can follow. There's sort of two main ways you can do this. You do want to make sure that you take sufficient time to weigh up the employee's response. So, depending on what the matters are, you can simply, say, look, we've listened to, you put the things to the employee, they respond to them, you say, look, we're going to step out of the room and discuss your responses, and we'll be back we're going to have a break and we'll come back and we'll let you know of our decision. Again, like with warnings, you do not want a termination letter written before you go in and just have it sitting there in an envelope. That means you've already made up your mind. Very hard to demonstrate you've given procedural fairness when that happens. So you can leave the meeting, you can go out, you can discuss it. Now, I highly recommend if you're getting to a termination meeting that you don't do it on your own. You do have someone with you, whether it's another manager, particularly if the employee's got a support person, but you've both got someone there to take notes. If it's quite a complicated issue, if there's a lot of new information that's going to come up, or it's quite sensitive, you might conclude the meeting and say, look, thank you for responding to all these things. We're going to send you home without pay for 48 hours, and we'll reconvene with you on Monday, and and we'll let you know of our decision and what the outcome is. So it really does demonstrate that you've gone away and you've considered the outcomes. And look, I think if it's for highly sensitive, you've got an employee that is very likely to take an unfair dismissal, then it's often a really good idea to really show that you've given that time to think about it, that you step away and really consider those responses. You need to then, if you have made the decision to terminate, then you need to provide the employee with the reason for the termination in writing. You can provide it verbally first at that meeting, and then let them know, look, we have decided to terminate your employment. We'll be providing you, we're going to finish you up today. If you're terminating someone's employment with notice, it's very rare that you would ask them to stay and work out their notice period. You usually finish them up at the time and pay out their entitlements in lieu of notice. So you let them know what that looks like, talk about what equipment they have to return, etc., and let them know that you will follow up with a termination letter within the next 24 to 48 hours. Or you listened to their response and decided that it actually didn't warrant termination and it was a warning. So if it's not related to serious misconduct, then you need to ensure they are given the appropriate notice as per the National Employment Standards and their employment agreement. So if you have an employment agreement that offers more than the National Employment Standards in regards to notice for termination, that is what you need to offer the person. You need to pay them up to and including that date any wages or entitlements they've got, and such as leave and long service leave if they've been there a long time. Ideally, if you can do it, try and make the payment as quickly as possible. If there's equipment or keys or cars or things that they need to return, you can state that, this is what you need to return, or we can come and pick it up from you, and once that's been returned, we'll put your final pay in. That can be a really good way to incentivize someone to return things, but you can't withhold it indefinitely. You do need to, most awards actually state it's got to be paid within the next pay cycle, so it is good to check your industrial instrument in that case. So support people. While it is good practice to have a support person or offer a support person, there's actually no requirement for it at a disciplinary meeting, but it's really good practice, and it's considered a way to demonstrate that you've had a fair and reasonable process. But having said that, it's not you don't have to offer it. It is unreasonable to refuse someone who asks to bring a support person to a disciplinary meeting, because that can contribute to a finding of unfair dismissal. But I think if it's going to be a formal meeting, offer it to them. Some people will want one and some people won't. So a support person is there to give emotional support to the employee, to assist them in preparing for the meeting, advise them of options that they may have. They can assist them to work through those options. They can advise them of the likely process to be followed. They can assist them to present their views or concerns by helping them, articulate their thoughts. They can ask for a break if the employee is becoming upset or emotional. They can ask questions to clarify the process if required, and they can take notes. But I want to really touch on what they're not there to do. They are not there to take over the meeting. They are not there as a representative of the employee. It is a conversation between the employee and the employer. They can bring anyone they like as a representative. It can be a union person, it can be a lawyer, but they're not there to represent the employee. They're not there to speak on behalf of the employee. They're not there to tell them what they should or shouldn't be doing. They can't be rude or aggressive to anyone during the meeting. And if they're somehow involved in the issue at hand, so for example, a potential witness to something, they should not be a support person, and they're not there to provide any personal opinions. So when you start a meeting and someone brings a support person, I often start by saying, look, we're glad that you could bring a support person along to provide you some emotional support. They're able to take notes for you. If you at any stage you guys would like a break to chat about anything, we're more than happy to provide that for you. But I need to be clear that your role is here as support and not to speak on behalf of the employee. And if you interrupt the meeting, then you may be asked to leave. Now, if that support person does interrupt, generally I'm kind of like one strike is okay to say, look, I understand that, you're getting worked up, but again, this is not your role. As we explained, we have to ask you to not interrupt or not, whatever the issue is. And if they can't follow that, then you can actually stop the meeting and say, look, I'm going to ask you to leave because you haven't followed the guidelines we've given you. And then you can say to the employee, look, you're welcome to continue without the support person, or we can reconvene. You can bring a different support person. It doesn't happen very often. Most support people are fairly sensible. It's always interesting when someone brings a family member along, but I've had some interesting experiences with that. But, really they're there to provide emotional support. So let's get into the consequences. We're running out of time. So an unfair dismissal occurs when an employee makes an unfair dismissal remedy application and Fair Work Australia finds that the employee was dismissed, the dismissal was harsh, unjust or unreasonable, and it was not a case of genuine redundancy. So when is someone protected from unfair dismissal? So they're an employee of a national system employer, which basically means somebody who works in Australia who's been dismissed, is protected from unfair dismissal and is eligible to make an application for an unfair dismissal remedy. They must have met the minimum employment period that we talked about earlier on. So depending if you're 15 employees or less or more, that is either 6 or 12 months. And they earn less than the high income threshold. So that's currently $162,000 a year. They're covered by a modern award or they're covered by an enterprise bargaining agreement. An employer has 21 days from the date of their termination to make a submission for unfair dismissal. They need to fill in a form and make that submission to Fair Work. The current fee for submitting an unfair dismissal claim is $77.80. And look, if you've been dismissed and you feel it's unfair and you earn $1,000 a week and you put in a claim, now that amount is refunded to them if they win. If there's found to be no case, then that they lose that amount. But if you earn $1,000 a week and you end up with another 2 to 3 weeks at conciliation settlement, that's a pretty good return on investment. You cannot prevent someone from taking an unfair dismissal claim. If they're disgruntled and they want to do it, or they meet like an adverse action claim, they can do it. But you can be in a really good position to defend it. And the burden of proof is always on you as an employer, and that is why this disciplinary process is important. So what are your legal risks? They're going to ask, was there a valid reason? Was the employee notified of that reason? And were they given an opportunity to respond? That's procedural fairness. So the ultimate question is there enough information to justify the termination and ensure the employee was provided with procedural fairness? And to determine a valid reason relating to conduct, the Commission will determine whether, on the balance of probabilities, the conduct allegedly engaged in by the employee actually occurred. So the fact that you've provided the warnings and the evidence in those warnings and the notes from meetings and able to present that to Fair Work is how you demonstrate that. And the burden of proof is on the employer to demonstrate that it, what actually happened, not the employee to demonstrate it did or didn't happen. So you'll also hear of what's called an adverse action claim, or also known as general protections claim. And so this is different to a unfair dismissal, and it's about protecting workplace rights. So it's where there's been an adverse action taken against the employee. Now that could be a reduction of hours, a reduction of pay, but in this case, talking about termination, termination has occurred. But it was because, and the employee claims it's because of a workplace right. A workplace right includes asking about their pay, for example. Industrial activities, they're a member of a union, or they were discriminated against, or where an employee is dismissed because of a temporary absence due to illness or injury. And this is available for past, present, or prospective employees. Now, this is why when we talk to clients and they start talking through all the issues, and one of the issues that comes up is, and they took all their sick leave, we say, well, let's not talk about sick leave, because sick leave is a protected right that people can take. So as long as they're provided evidence, they're allowed to take it. It's not grounds. Now, if someone is on long-term, we could do a whole podcast on long-term injuries and when and how you can terminate someone if they are going to be absent from work for more than 90 days consecutively or in a 12-month period. But just taking their sick leave, which is an entitlement, is you know, if that's part of your reasoning, it could be grounds for a general protections claim. So the question will be, was there an exercise of a workplace right? So, for example, did they make a complaint about their employer? Did they access their sick leave? Did they question their pay? You have to substantiate what the real reason was for the termination. And they're going to ask who the decision maker was and who made that decision and did they have all the information. So really the key issue is there enough evidence regarding the reason for dismissal to discharge the onus on the employer? So what that means is, can you provide enough evidence, i.e. copies of warning letters and meeting notes and things like that to show no? If the employee says, oh, they terminated me because I told them I had a mental health condition, and you say, well, no, that wasn't the reason we terminated you. The reason we terminated you was because you weren't performing. And here's the warning process we've been going through with you. You know, you need to be able to prove that that wasn't the reason. And it's also the reason why we say when you terminate someone in the probationary period, they used to be Smith, you don't have to give a reason. Yes, you do. You need to say it's because you haven't been able to demonstrate the requirements required of the job, or you're not performing to the level we needed, or you are not the right cultural fit due to behaviours demonstrated, because then you've provided a reason. If you don't provide a reason, an employee will say, oh, well, this is the real reason, and you didn't provide what the reason was. So in terms of discrimination, again, that's protection, so that, you know, the decision wasn't made based on a protected right of age, gender, disability, mental health. So again, is there enough evidence regarding the reason for termination to establish that the reason wasn't because of the discrimination? And it requires positive evidence of either poor performance, bullying, misconduct, whatever the reason actually is. Positive evidence means you have to show that it happened. They don't have to show that it didn't. So again, this is why we go through a disciplinary process. So we do have the Small Business Dismissal Code. This applies to businesses that are employ less than 15 employees. It's calculated on a head count of all employees, including casuals, who are employed on a regular and systematic basis. Small business employees cannot make a claim in the first 12 months. And if an employee is dismissed after this period, the employer has followed this code, then the dismissal will be deemed fair. I'm not going to go into detail of the specifics on the code. It's available on the Fair Work website. It is still about providing procedural fairness. You still have to put allegations to an employee. You still have to give them an opportunity to fix it, but it's not as onerous a process required as it is when you're over 15 employees. But to be honest, if you take the same approach, whether you're under 15 or over 15, you're always going to be protected. It's just if you're less than 15 employees, you may get away with, you know, one less warning, and you don't have to provide it as a letter, but it is highly recommended. It's a really good document to have a read through if you're a small business and you are going down this process. It has a checklist of things that you can follow to check that you've done them, but ultimately it's still a similar process. It's still about providing that procedural fairness. And ultimately, I think if it was one of your family members that their employer was looking to terminate, you would hope that they had followed a fair and reasonable process. And all Fair Work are there to do is check. They're not there to demonise employers. They're there to check when an allegation is made that the right process has been followed. So how do you avoid getting it wrong? Avoid making general statements and be clear on your reasons. Have objective evidence that substantiates your claim. If you have a list of issues with an employee and some of them are really concrete and some of them are quite vague, don't worry about the vague ones, stick with your concrete ones. If the issue relates to interpersonal skills, before you jump to termination, really consider other actions first. Have you given feedback? Have you given them mentoring and training? What other options have you gone through before you've jumped to termination? Explain your concerns to the employee and ensure they understand the issue and are provided with that chance to respond. And be sure you're consistent. So if there's inconsistent treatment, of similar conduct previously by other employees, that issue can be relevant. So if you've decided on this instance you're going to terminate someone, but they can show that another employee 6 months ago did exactly the same thing and just received a warning, and there's no substantial difference, that could put you in a case of an unfair dismissal. So in terms of the documentation, I just wanted to briefly touch on that again. The documentation is critical. Take notes. Send yourself a text or an email if you're, a small business owner. Send it to another manager. send it to your HR consultant. I got one of those today from a client. It documents and times and date stamps it. You know, I had a conversation with John today. This is what I went through with him, because you know what, if you're trying to gather the evidence, you know, down the track, and you're going to do a warning, and you know you've had multiple conversations, but you really can't remember when they happened or how they happened, you know, make a couple of quick notes. I talked about performance improvement plans. They are definitely an option. There are some good templates out there. We certainly have one. Follow up. By that I mean, if you say that you're going to follow up that employee every 2 weeks for the next 8 weeks, you need to follow that process. If you say we're going to follow up, you know, if you're asking someone to improve their performance or their sales, and you say we're going to follow up with you in a month's time to see how you're tracking, and you don't do it, then you might as well, you've just got to start the process again almost, because you're not following your own process that you've set. And be consistent. Provide consistency. The reasons we find that people don't avoid the difficult conversations, they're concerned about the employee's response. What if they leave, particularly at the moment when it's really hard to employ? What if they leave? This person, they always turn things around on me, and they always gaslight me, so I don't want to have the conversations with them anymore. So you might fear the impact on the relationship, and I think if you do handle it in a fair and reasonable manner, there might be some initial impact, but the person might actually respect you for providing that feedback, and it helps them. People can't change what they don't know. I haven't got time. That's one of my favourites. If you haven't got time to manage someone in a disciplinary issue, then you haven't got time to manage people. If it's not your priority, then you know, why are you even bothering with the process? You either got to put up with the behaviour or the conduct, or you've got to deal with it. It's not my job. Well, if you're the manager, it is. I don't know how. That's a very common one, and that's where we can certainly help. And it's hard. It is. It's not easy. I've had to do it as a manager. I've actually had someone, you know, I haven't received a warning, but I've had meetings about, you know, issues, and you know, it is hard. It's not an easy conversation, and that's why you need to be prepared. So, as we have gone to time, and I'm happy to hang around and answer any questions anyone's got, I just want to mention we have some upcoming training for both mental health first aid, some blended online courses that we're running, public courses. We also have some leadership training workshops coming up in Melbourne, Brisbane and Perth in August, September and October. That's really training where we go into a lot of depth about setting expectations, really practical training on how to be a good manager, what is leadership, right through to the how do you, you know, have these disciplinary, you know, processes, and you know, what I've covered here is part of what we cover towards the end of that workshop. If anyone would like more information on those, I will include them when I send out a copy of the presentation. And that is it for me for today. It is a big topic. There is a lot we can go through. You can follow us on the socials. I encourage you to sign up for our newsletter so you can hear about things that we've got coming up in the future. But I am going to open up the question and answer and answer some questions. So if anyone has got any questions they want to ask, please feel free to throw them in. The first question I have is, when we hire our 15th and subsequent team members, everyone's contract requirements adjust instantly. Now we're over the magic 15 number. Yes. It's not that the contract requirements, it's just the fair work requirements change. That is the line in the sand that they've drawn. If you once you step over that line, the requirements change. And, you know, to be honest, employees generally don't know about it. A lot of employers don't know about it. And that's why I always say, regardless of the process, really just follow, if you follow a fair and reasonable process that's procedural fairness. The other thing is, if you do that, if you know that it's not easy to terminate someone, but if you know you've given them the feedback, you've given them the opportunity to improve and they haven't, that actually helps you as a person to go through that process. But yes, it is a magic, I call it the magic number because it just instantly happens. And we see employers that sometimes then drop below it. We also see employers, I should mention, that maybe have several different entities set up in their company to try and keep numbers below 15. Sometimes Fair Work can sort of, lift up the curtain and have a look underneath and see whether that's really legitimate different entities, or it's just to try and keep the numbers under 15. But yeah. Hopefully that answered your question. Thank you, Tim. Anyone else got any other questions that they would like to ask me? Well, they've got me now. The other thing, of course, is you're always welcome to book an obligation-free consultation with one of our team by heading over to our website and booking an initial meeting. You know, a lot of the issues that come up around termination and certainly that come up around disciplinary actions, they're not the sort of, you know, that not everyone wants to talk about them in a public forum, and they're often quite nuanced. And, you know, for us, we really need to understand the nitty-gritty of what's happened up until that point, and what are the details to be able to give the right advice. So it is quite possible that you know, it's better off getting one-on-one sort of support through these sort of issues. And certainly as a business, we support clients quite a bit through writing letters, you know, helping. You know, we do have times where we sit in termination meetings, and we are the support person for the employers. Pre-frame one of these hard conversations to nip more issues in the bud. Okay, so we always suggest have the awkward conversations. Don't avoid the awkward conversations, and you know, because eventually they'll become a hard conversations. I think it's regular feedback with your employees. If you're not happy about something, don't let it fester. And it could, you know, really quick, informal, going, hey, next time, can you do it this way? Or, look, you know, I happened to overhear how you were speaking to so-and-so at the front counter the other day. Look, I felt that was, you know, the way you were speaking to them was inappropriate. You know, maybe next time we could do it a bit differently. You know, if you have regular catch-ups with your employees, give that feedback. But what I see happen is that people don't want to, they go, oh, that's petty, I don't want to address it. But when it starts to become a pattern of behaviour, and also if you don't tell, as I said, if you don't tell someone you're not happy with what they're doing, or they need to fix it or change it, they don't know to change it. And I have seen many instances in my career where someone is like, why didn't you tell me this before? You know, why didn't you tell me you weren't happy with how I was doing this? Why didn't you give me that feedback? So, you know, when we do leadership training, we have a slide called Feedback is a Gift, and it really is. So it's much easier to sit down and go, hey, let's, you know, I want to have a chat. What, you know, how are you going? What are you enjoying about the job? What are you finding challenging? Often people are quite self-aware and they might be aware of it, and that gives you the opening to address it. But if it's particularly if it's behavioural, if it's about how people are speaking to other people or some of the things they might be doing, you definitely want to nip those in the bud. And a quick informal conversation to just say, hey, you know, I noticed this, I need you to fix it. That's not how we do things around here, can be really helpful. Are there any other questions that anyone has? Okay, well, oh, not a question, but thank you. Thank you very much for the feedback. I appreciate it. Look, thank you everybody for attending. We haven't quite worked out what our next topic is going to be. We've got a pretty big month coming up with mental health first aid training and leadership training. Anyone that has been a previous client, you know, it may be eligible for a discount to attending that training, so please reach out to us if that's the case. I will include the links for all of that other training, and certainly we'll let you know when our next webinar is. We're actually considering, we're really open to getting some suggestions if there's any particular topics you'd like to see us cover. Any of our previous webinars on employees versus contractors or leave, they're all on our website under advice videos, and they're also on our YouTube channel, so they're all there to watch. And we're also considering starting some very specific industry based webinars, so maybe targeting some of the groups of industries that we work with and doing something a lot more specific to them. So we might do one on building and construction, and we might do one on, you know, psychologists or something like that. So where we have a lot of clients in a particular cluster, we will be looking at doing some like that. But if you have any suggestions, please send them through. Otherwise, I hope that everyone has a nice night. I hope that they enjoyed a glass of wine. I'm going to finish the rest of mine now. I have a new golden retriever puppy. I'm going to go upstairs and enjoy my wine and have some cuddles. And I wish everyone a great evening. Thank you.